Thanks, Connor. And thanks to all the earlier speakers as well. This is a great event. It's not often I get the opportunity to listen to and discuss the area around my own PhD research, so it's great. I want to talk to you about democratic experimentation in the 1922 Constitution, which might seem like an odd association because to many people, when they think of the 1922 Constitution, they think of conservatism. When I was carrying out my PhD research, I used to ask people, have you heard of the 1922 Constitution and what are your views on it, or what have you heard about it? And generally, people used to say things like, it was a British creation, it was imposed on us, it was all about the king, it was an imperial document, it caused the Civil War. Some people used to say it was a religious document. One person actually said to me, I'm sure that wasn't a real constitution. Worryingly, that was a law student. But these are the sorts of things you hear about that document, and it has gained this sort of bad reputation. But in fact, the document was very experimental. You could call it a liberal, you could call it a radical document in a way. So I just want to look at that particular side of it today. Just a tiny bit of background. The committee which drew up this document was a mixture between lawyers and laypersons. Collins and Griffith chose this particular committee, and probably the most influential person on the committee would have been Hugh Kennedy. Of course, later went on to become Chief Justice. But there were a number of other lawyers on the committee. So you had Murnaghan, who went on to the Supreme Court, John O'Byrne, who went on to the Supreme Court. You had an American lawyer, Clement J. France. You had Kevin O'Sheil, who was involved in the Dáil courts. And then you had a number of laypersons. So Darrell Figgis, who was actually the chairperson, he was a writer and involved in Sinn Féin. And you had James Douglas, who was a Quaker businessman. And of course, you had Alfred O'Reilly, who was professor of maths in UCC, later president, and a deeply religious man. So lots of different backgrounds there, no women, of course. But although they all came from different sorts of backgrounds and they were influenced by different things, they all had almost the same type of vision of what they wanted for the fledgling state. And if you look through both the early drafts and the finished constitution, it's quite clear that one theme in particular that they all felt very strongly about was the idea of popular sovereignty. To me, it looks like the foundation stone of that whole document. It's enunciated first in Article 2. In the earlier drafts, it had been set in an even stronger form. Originally, they had used the words of Pearse, but they were toned down later on during negotiations in London. But the principle that power derives from the people was retained, and that was very important for the committee. They felt that in order for the Irish people to accept this new regime and this new document, that it was very important that the people were seen to be the ultimate power in the state, or the true masters of the state. So a lot of the experiments within the Constitution flow from this idea of involving the people in politics and bringing power back to the people. This was partly because it was felt that the old regime was full of corruption, and by involving the people then that there would be a renewal of this spirit and this type of politics in Ireland. Also, the committee wanted to get away from British-style party politics, or what they referred to as party politics. In Britain, they didn't like the idea of political parties as such, and they felt that this new regime, based on popular sovereignty and based on a new democratic ideas, would allow for independent thought, would be above party, and would get away from this traditional British-style politics. So those were certainly inspirations for these experiments or devices, which I'm going to look at in a second. And they come from a number of different sources. The post-war European constitutions were a major source of inspiration for the committee, and particularly the Weimar Constitution of 1919. Figgis was very interested in that particular document, and they did use quite a bit of it. And I know Jared Hogan has recently done some research into links between the 1937 Constitution and the Weimar Constitution, and you can see that a lot of the provisions that he refers to that are similar in both from 1937 are actually the original 1922 military provisions. So they did borrow quite a lot from those constitutions. And of course, you had this post-war democratic zeal, which sort of runs through all of those European constitutions. But they also took some experiments from the Swiss and the US constitutions, which I'll look at shortly. But also the Gaelic state was a major source of inspiration for the committee, or at least their idealised version of the Gaelic state. And this was the ancient Ireland, which had existed before the Normans arrived in Ireland. And they had these very romantic, idealised version of what this state was like, but they were able to link their experiments back into this state, or at least draw on this. And actually it was interesting, the question earlier about socialism and Russia and what was happening at the time, because in the early drafts of the 1922 Constitution there were many sort of socialist or left-leaning types of provisions, but the committee were very anxious not to be seen as communist. And in particular, C.J. France, his brother, had been in Russia recently, so he was trying to be very careful not to be seen as communist. And George O'Brien, who was an economist that the government asked to criticise the constitution, he was not impressed at all by these left-leaning provisions, and he said, you know, they should really be taken out. And the provisional government did insist on watering down a lot of those provisions. Later on, even when it went to London, Winston Churchill criticised it as being Bolshevik. So there was that aspect of being afraid of Russia, but the committee would argue that those provisions came from the Gaelic state and not from Russia, so that these sort of socialistic ideas, but they weren't socialist. They were very careful to point that out. So that was an influence. Also, the older Irish constitutional documents, which we've been hearing about, they wished to link this back to those documents, so they would have used words and phrases and the thinking behind those documents, and also the writings of even older Irish patriots, people like Wolfe Tone, James Fintan Lawler, and so on. So moving on then to look at the actual experiments themselves, a major one was probably the legislative referendum, and its twin then, the initiative. So the idea of a referendum was included in the Constitution for constitutional amendment, first of all, but also it was included as a sort of a legislative veto. So this was linked to the idea, again, of involving the people directly in governance and in legislating. And it was hoped that you could achieve this by inserting these types of devices into the Constitution. So Article 47 contained this legislative veto. The idea basically was that if you had legislation which was passing through Parliament and the people weren't quite keen on this, that they could get a petition together and that they could force the issue to a referendum. So the people could be actively involved in legislation and in governance. And when Kevin O'Higgins was introducing this in the Constituent Assembly, he explained what the purpose of it was. He said, personal actual contact between the people and the laws by which they are governed is advisable in a country where the traditional attitude of the people is to be against the law and against the government. The referendum, we consider, will be a stimulus to the political thought and the political education of the people. So again, the committee had this idea that people would become interested in politics then because they could become actively involved in politics. Article 47 then had its sort of partner, its twin in the initiative in Article 48. And this is the idea that the people would propose their own laws and their own constitutional amendments. Now, the initiative wasn't actually set up by the Constitution, but the machinery for setting it up was included in Article 48. That might suggest that there might have been some reluctance in terms of setting up the initiative straight away, and obviously there are dangers with these sorts of provisions. We've seen things happening in Switzerland, the minaret ban and so on. So possibly there were some reservations about actually setting it up itself in the Constitution, and that's why it was put in there so that it could be set up at a later stage. Now, neither of those two devices were ever actually used. When the first attempt came to actually use the provisions, they were actually just swept away from the Constitution. It was De Valera decided he would initiate Article 48 to try and remove the parliamentary oath from the Constitution. And since the Constitution was a little bit vague and it didn't really explain how you could set things up under Article 48, as normally happens in politics, they set up a committee to consider how one should proceed. And as this was happening, then the government decided actually it would be expedient at this stage to just delete these provisions from the Constitution because of the power that they gave to a minority, De Valera, whoever, to basically wreak havoc on the Constitution. So it's interesting, the same people, Kevin O'Higgins obviously wasn't there, but the same people who were extolling the virtues of these ideas in 1922, in 1928 were then saying, you know, we have enough of this stuff in the Constitution, we don't really need this, it's expensive, it's dangerous, let's just take it out. So they were both removed in 1928. Without ever being used. But today, interestingly, there are at least 3 movements that I'm aware of that are campaigning to try and reinstate these types of devices, particularly Article 48, into our Constitution today, which is an interesting development. Another experiment then, which was inserted into the 1922 Constitution, was the idea of external ministers. Now this was an idea conceived by James Douglas, who was one of the members of the committee. The theory behind his scheme was that a new form of executive could be created. The idea was that it would be above party. It would function simply for the good of the state. So Douglas suggested the creation of a 2-tier executive. The first group would be responsible for policy. Now, it was never stated in the Constitution which ministers exactly should be members of this first tier, but Douglas would have suggested that the President of the Executive Council, obviously, but also ministers responsible for things like defence, state, finance and foreign affairs, so these policy type areas. The second group then he suggested should be non-parliamentarians. They would be appointed on the basis of their technical expertise or skill in a particular area. They then would have responsibility for matters such as agriculture, education, justice, those types of issues. So they would be expert outsiders. They wouldn't necessarily be politicians. Indeed, they'd have to resign their seats if they had been elected to the Oireachtas. But the principal idea was that they would be experts in the particular area that they would be appointed to. Now, a happy coincidence of the scheme as originally envisaged by Douglas was that since these ministers would not be parliamentarians, they wouldn't sit in Parliament, then they wouldn't have to take the parliamentary oath. And of course, Collins was delighted with this idea because it meant potentially that De Valera and his supporters could enter into government without compromising their position because they wouldn't have to take this parliamentary oath which offended them. And of course, Collins was involved in negotiating the Collins-De Valera election pact at the time. Now, this wasn't the main motivation of the external minister's idea, but it was certainly a happy coincidence. And unfortunately, when the Constitution was brought over to London in June of 1922, the British weren't very happy with that particular draft. They didn't quarrel as such with the external minister's provision, but they did insist that all ministers would have to take the parliamentary oath. So that sort of ruined Collins's dreams and it maybe removed some of the attractiveness of this particular provision. When the provision went to the Constituent Assembly, there was also a lot of reluctance. A lot of the deputies weren't really sure how this would work with this 2-tier idea and whether they would really be the executive or wouldn't they be the executive, and why weren't they going to be parliamentarians, and how would it work with individual ministerial responsibility versus collective responsibility. So it was sort of touch and go in the Constituent Assembly as to whether this idea would actually end up in the Constitution. But a watered down version did make its way into the document. The problem is that the scheme was never really put into practice. So we know the idea was that it would be experts. So you'd elect the Oireachtas, they would elect the president of the Executive Council, and then a committee which would be representative of all the interests in the Dáil would then elect these external ministers. So you'd have somebody who was an expert in agriculture running the Department of Agriculture, almost like a manager. But the first government, for example, decided to elect 3 external ministers. They were all pro-treaty Sinn Féin deputies. So you had PJ Hogan as Minister for Agriculture, JJ Walsh as Postmaster General, and Fionn Lynch as Minister of Fisheries. In the following election, then, the same ministers were re-elected, except you had an addition in local government. And there doesn't seem to have been any real attempt to ensure that they were actually experts in the area. And so then by 1925, the amendments to the Constitution Committee recommended giving a choice to the President of the Executive Council as to whether or not to bother appointing any external ministers. And after that, no further external ministers were ever appointed. So the scheme failed, and there were lots of contributing factors. The issue of finance was one quite big one, but the true downfall of the scheme was that you never really had any external ministers appointed. So they never really tried out the experiment that had been inserted into the Constitution. So they were supposed to be above politics, these ministers, but because they never really gave it much of a chance, that crucial element in the scheme was ignored, then obviously the whole thing fell apart pretty quickly. Now, another experiment which was related to the external minister's idea was the idea of functional or vocational councils. And this was another idea which was intended to involve ordinary people in politics by setting up groups based on trades or aspects of the national life, and using these as advisory groups in the Oireachtas and in government. It was also envisaged that once they were up and running, that these groups would elect the external ministers, or at least that was the idea that Figgis had. This comes from Figgis's research into the Gaelic state. Darrell Figgis had written a book in 1917 on the Gaelic state, and he had written about how these councils really aided in terms of how they governed the people. Now, also, you had similar types of ideas in the post-war European constitutions, as well in the Polish constitution and the Weimar constitution in particular, so they were able to draw from those as well. There were a couple of different schemes put forward as to how they would incorporate this functional idea into the Constitution. The idea that Figgis had was that these groups would become involved in electing the external ministers. One of the secretaries, Mortished, did a lot of research on this as well, and he came up with a couple of alternative suggestions. One was that you could have a functional chamber, so that the Shannon, for example, would be a completely functional vocational chamber. The other idea was based on the German example, where you would have these sorts of councils who would advise the Oireachtas, and that was the scheme that Mortished felt would be most appropriate for Ireland. It was decided, however, to go with Figgis's idea and to adopt these councils as sorts of advisory councils, but something that would be involved in electing the external ministers. Funnily enough, the idea was retained in a slightly different guise under Article 15.3, but it was Mortished's scheme which was envisaged for the 1937 Constitution. Again, this was an idea that was never really initiated. In 1922, there were no groups which were in existence that could really form the basis for these councils, besides the Law Society and the Medical Society. So Figgis made the point that first we have to work on setting up these councils, and then at a later stage they can be involved in governance and in legislating. So again, it was an experiment that nothing ever really happened because it was never followed up on. And this is also part of what I've referred to as an anti-party theme in the Constitution, or this idea that the committee wanted to get away from the British dual party system. And another experiment which was inserted to get away from that idea was the idea of PRSTV, proportional representation, which the committee felt would create a multiplicity of parties in the Dáil, and so prevent the advent of a dual party system. Didn't quite work out as they had intended there, but it's quite interesting at the moment to observe what's happening, given that it's not an entirely dissimilar situation which was envisaged by the committee originally, that you wouldn't have a majority and that you'd have all these different independent groups. So it's not quite working out very well at the moment. But it was hoped, again, that groups could come together to vote on issues, but that independent thought would flourish in a system that wasn't restrained by the demands of parties, and that government would be truly answerable to the Dáil under these sorts of systems with these experiments. But obviously the Civil War split and its effect on politics means these didn't quite transpire as had been expected. Another sort of experiment is the Shannon. Now you might say, how is the Shannon an experiment? The original Shannon also did form part of this theme, this idea of getting away from this political party system and bringing politics closer to the people. The idea of having a second chamber in the first place came about because Griffith had promised it to the Southern Unionists in terms of guaranteeing representation. But the committee realised quite early on that actually having a second chamber could form part of the fight against party politics. And they originally envisaged a very small house of about 30 or 40 people. Later on, after negotiations with the British and the Unionists, that rose and rose, and it became 60 people in the end, which didn't really work in terms of the vision that they had. But it was envisaged that this second house would comprise senatorial persons of high integrity. So you see there, Article 30 provided that citizens should be proposed on the grounds that they have done honour to the nation by reason of useful public service, or because of special qualifications or attainments, they represent important aspects of the nation's life. And at the beginning, that is how it did function. There were no organised political parties in the early Shannon as such, and it did function as a forum for independent debate and discussion. For example, Donal O'Sullivan has written of the first Shannon that the new Senate was in a position to realise in microcosm Thomas Davis's dream of a united Ireland, wherein all men of goodwill could work together in a self-respecting, self-governing motherland, and given the conditions, a spirit of cooperation there engendered and fostered might in time infuse the whole polity. It sounds lovely, doesn't it? But he gives it the example of, for example, the election of Lord Glenabbey, who's the guy in the wig there, as chairman of the House. So despite the fact that he had been Edward Carson's right-hand man in the campaign of opposition to Home Rule, and Donal O'Sullivan says, well, you know, this was making it clear that these things belonged to the dead past and everybody could work together. And you can see other characters involved in the first Shannon, Alice Stopford Green, Jenny Wise Power, for example, you've Yeats and Hyde. You had all of these independent figures, and looking through the list, there aren't very many that are associated with parties. If they are, it's sort of a weak association. Of course, the Shannon turned out to be an unmitigated disaster in terms of its electoral system, whereby the whole country was going to vote as one constituency for the Shannon, and because of the amount of people who had put their names forward, you had massive big long lists, and the whole of the country voting as one constituency looking at these big lists. And the first election in 1925 happened on a very wet, rainy day. Very few people came out to vote, and so the whole thing cost a lot of money and was very expensive, and afterwards it was decided actually to take out that popular element of voting for the Shannon. So the Shannon as a whole in the beginning functioned in a way as this independent house. Of course, with the entry of Fianna Fáil into politics in 1932, party lines began to harden, and at that stage then it turned into more of the Shannon that we recognise today. Lastly, another experiment which was included was a judicial review. And this is one which actually did succeed, although it took many years and a different constitution. Many people don't realise that the 1922 constitution actually contained a judicial review provision, but an American professor from Harvard described it as the most arresting provision in the Irish Free State Constitution. The reason being it constituted a massive break with the British tradition, whereby Parliament was supreme and judges could not question the actions of Parliament. So popular sovereignty had already been proclaimed in Article 2, but this was an even further extension of this, and nothing like this had ever been seen in a Dominion constitution. We're not quite sure where their inspiration came from. Obviously, you had the American example. You had an American lawyer on the committee, and Kevin O'Sheil had written a book about the American Constitution. So obviously, the American example would have been very influential. But you had the beginnings of a judicial review type of movement in Europe at the time as well. So we're not quite sure where it came from, because the committee don't really discuss this in their documents. We're also not quite sure what was intended. Did they intend to spark judicial review along the lines of O'Donnell and Walsh later on, or along the lines of the American example? They don't really go into this in their discussions, and in the Constituent Assembly they don't really discuss it at all. So unfortunately, we're a little bit in the dark as to what actually was intended by the judicial review provision. And of course, it never really took off under the 1922 Constitution. Partly down to the legal profession itself. The lawyers and judges had all trained under the British tradition of parliamentary sovereignty, so they were unused to this idea of judges questioning the actions of Parliament. The judiciary had the opportunity to ignite it in the State Ryan versus Lennon case, but besides Kennedy, all of the judges took a very positivist approach, and so perhaps the chance there was lost. I'm just going to move quickly on, because I think I'm running out of time. So basically, what I'm trying to show you today is that the Irish Free State Constitution is a lot more than maybe its reputation would give you the impression of. And I think in this decade of commemoration that we're in, I think we owe it to the drafters of that document to look beyond the myths and look beyond the controversies of that document, and to look at what was actually intended, look at the spirit behind it, and look at these brave innovations, which, like, if you look at it from a very practical point of view, none of them really succeeded. But at the same time, it was such a brave experiment. When they could easily simply have followed the British tradition, it would have been much safer and more conservative. But instead, they wanted to do something different. They wanted to prove to the Irish people that this was going to be a new, unique Irish state. And I think this is really the legacy of the Irish Free State Constitution.